We'll call you first witness.
Oh, very Cross.
Mr. Cross, you raise your right hand, you swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, I will.
State your full name, with whom you're employed, in what capacity.
Full name is Barry T. Cross. I am the program coordinator for Clinton Cumming Monroe,
For the drug-
ALC Drug Court.
Okay, go ahead.
Mr. Cross, as part of your duties, have you been filling in, assisting Monroe County since Mr. Lincoln?
Yes, I have.
Okay. And are you familiar with the case involving Commonwealth versus Courtney Oliver?
Yes, I have. I've had some few months of supervision, but not the full length of the case. But I am knowledgeable of the case.
Was she terminated from drug court on July the 20th, 2023?
Yes, that is correct.
And can you tell the court why she was terminated?
On April 23 of 2021, Ms. Otterburn signed the it's called Kentucky Specialty Courts Agreement of Appreciation, which is stipulations that they have to comply while they're in the program. On number 13 of this stipulation form, you want me to read it word for word, Your Honor?
I don't know how long it is. Just tell me.
It's just a few pages, five sentences.
Is it Jesus wept or Paul's letters to the Romans? I don't know.
It's however you want. Anyway, it says, I agree to respect the opinions and feelings of other special court participants and not make verbal or physical threats or abuse towards special court staff or other participants. I also agree not to engage in any romantic or sexual relationships with other special court participants while actively involved in the program. I understand that failure to engage in appropriate behavior may result in a variety of sanctions, including termination.
Okay.
Did Ms. Oliver sign that agreement?
Yes,
She enrolled in the
yes.
and did she violate that?
She, on the 20th of July, Judge Costello and the team did deem that she did violate it and therefore was terminated from the program.
What specifically was the violation?
She was involved in sexual relationship with another client in the program.
Now, it also in June, did she have any positive drug tests or positive tests for marijuana?
If it's, yes, I don't have the order in front of me. 626 positive for marijuana, 429 positive for alcohol. And then, of course, the new violation was number 12, but it's the 13 in the old one that she signed. They have a new form now, but it'd be number 13 in the old one that she violated appropriate behavior.
I have no further questions.
Would you like to inquire?
Yes, Your Honor. Mr. Cross,
Move up toward the microphone a little bit, Mr. Cross.
Oh, I'm sorry.
Good.
Mr. Cross, prior to that June date, that 429 positive was in 2022, correct?
Correct.
And while she's been in drug court since 2021.
Correct.
Okay, what-
April of,
Okay, sorry, I didn't mean to cut you off.
I'm sorry.
What phase was she in when she was terminated?
She was in aftercare.
Okay, and aftercare is the last phase prior to graduation, correct?
Correct.
And during her time in drug court, she has not had any charges, correct?
No new felony or any misdemeanor charges.
She's not been alleged to have absconded from the program, correct?
Correct.
Okay. I have no further questions.
You have any redirect?
No redirect, Your Honor.
It's like calling witnesses.
No, Your Honor, you wish to make arguments.
Okay, thank you. Do we need Mr. Cross for anything else, or can he be excused?
No, I'm finished with him on this case. We've got a similar case.
Okay, well, if you just stand by, we'll call your other case. Go ahead and make your argument.
Your Honor, I understand that Ms. Arterburn has violated a rule of drug court. However, I don't think this rises to the level in which the statute, KRS 439.3106 contemplates revocation being appropriate. I think the court has other things that are available in lieu of revocation, such as sanctions. The statute calls that there must be a significant risk to prior victims or the community. I don't think that's been demonstrated in this. Additionally, the statute accounts for what the severity of the violation is, including the risk of future behavior or criminal behavior that it could incur, and what other interventions are available. I think this court does have the ability to sanction Ms. Arterburn, and that would be the appropriate thing to do. It's not been demonstrated that she doesn't have the ability to fully comply with supervision, but she did have a violation. Additionally, it's not been demonstrated that she has created a risk to any individuals that are alleged victims in this case or the community at large. So I'd ask the court not to revoke her at this time and sanction her instead.
John, this is a novel issue for the Commonwealth. We've not had this come up in my 20 years of practice or prosecution. However, I would say, besides what the statute says, the drug court is probably, I believe, the best program we have in the state to help people. And you have to maintain order in that program, and people have to follow the rules. And you just can't decide on your own that you can violate those rules and there not be any repercussions. So, you know, the staff did what they had to do because she wouldn't follow the rules. Whether she deserves a sanction or deserves termination, that's up to the court. But there has to be some order maintained.
What's the Commonwealth's position as far as what would be
Well,
appropriate
my
in this case?
understanding is I would ask that she be revoked. I think she would be eligible for shock. And I was looking at the file and I can't determine whether this is a probation or a pretrial diversion that she's on. And so my file.
It says a pretrial diversion revocation. Did you check the file there for a second?
I think there's ways to handle this case.
Well, I'm asking,
So I'm asking first.
I'm checking my file as well as we had thought perhaps her diversion has been previously voided, but she was not entirely sure. And I'll be candid, I did not
Motion to
originate this.
Pretrial diversion. Yeah, we have a diversion.
she thought the diversion had previously been voided or revoked.
It was,
There was an order here.
okay, so she was the inner drug court. It wasn't her.
And I think she was just confused a little bit.
What was the problem then? Why were we going to revoke her the first time?
She had positive tests for methamphetamine, marijuana. They tried different treatment options and put it down to drug option.
Well, I'm gonna, there comes a point where this particular drug court situation was after she'd been given a pretty big break on a pretrial diversion and not revoke at that time. So this is more than the second bite of the apple here for Ms. Arterburn. In addition to the statutory obligations there, I must take into consideration the effect it has on the entire drug court and the effectiveness of the drug court. We completely will destroy the drug court if we give people a second chance like she was to go to drug court and then she ignores the rules and doesn't comply with the rules. So I'll take into consideration any other sorts of things. I really don't know what to do. She ignored the conditions of her pretrial diversion previously, and the sanction was to let her go to drug court. Now she's ignored the drug court. Seems like she's being relatively hard-headed about this sort of thing. You almost had the thing finished. So I'm going to revoke a pretrial diversion, and I'm going to schedule a sentencing, and we'll take a listen that might be able to help her. So the pre-sentence investigation report and sentencing shall be on September the 21st. Okay, versus James Farber, 21 CR 00122. Are you James Farber?
Yes.
Born in 1994. Last four digits, social security number 0603. We're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, this is also a pretrial diversion. We have a 3-year sentence on possession of stolen substance. This is a case to Ms. Alderman. Okay, so we have the same violation.
Okay, you want to come up and take your first witness? Raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Okay, you may proceed.
Mr. Krause, you stated earlier that you've been assisting in Monroe County regarding the drug court team. Is that correct?
Yes, I had to cover while Mr. Mink took another job in Warren County.
Are you familiar with Mr. Farber's case?
Yes, I am.
Are you familiar with his violation?
Not the early violations, but I am with this current violation that was found to have been terminated from the program.
Okay, and why was Mr. Farber?
He was also violation number 13 in inappropriate behavior with sexual And of course, another client in the program which deems can be terminated on the 20th during their staffing and court session, Judge Costello did deem to enforce number 13 and terminate.
Sure.
Prior to this, Mr. Barber had no allegations of absconding from the program, correct?
No,
No new charges, correct?
no,
And had just had 2 positive alcohol tests in September and October of 2020, correct?
correct. He was on no issue except number 13.
I have no further questions. Your Honor, I would just note, this is a case where he was ordered to go into drug court originally as the term of his diversion in the original plea agreement. I think that once again, statutorily, there's been no evidence that he poses a danger to alleged victims or the community at large. I think that he statutorily, this is not considered a severe violation in which it is impossible to supervise him within the community. I do think a sanction is appropriate in this case. And I would ask the court to consider that, as I think there are other options in lieu of revocation that would align with what the statute calls for.
I would have the same argument, Your Honor, about maintaining order. Drug court, this is a different situation in that he did not have a second bite at the apple. This was his first infraction. So, and he's on a diversion. If the court wants to sanction him rather than revoking the diversion, the Commonwealth would have no objection. But I think some sanction is in place, needs to be ordered.
Do you sit on the drug court over here?
No, Your Honor, when they moved the drug court to 8 a.m. on Thursday, and I have such a docket,
Yeah.
that's all I can do to get over
Does someone sit in your stead? Who
here.
does it?
Mr. Hunter, Mr. Gordon Anderson.
Well, I'm not familiar with, I don't know whether I knew about this clause or not as far as individuals being intimately involved with each other as being, a condition. I'm not aware of that. Here's. It's down there, go watch the stuff and just unplug it, bring it up. It's a cord for this thing. Here comes my calendar's about to die. I understand the purpose for that as far as keeping order or not. Puts me in a very difficult situation as far as a rule is a rule, but I can't order the drug court to sanction him because they have the authority to determine who stays in the drug court. That's been given to them. Judge Christie Costello has that court, and I'm the one that does the ultimate sanction to determine what goes on. I wonder if any warnings were given. Do you know whether any warnings were given to these individuals that they should stop this relationship or anything?
I believe both individuals had prior knowledge they were involved. And I believe both individuals probably was hinted to cease their relationships. And they knew.
Well,
Every time we do orientation, we go over to stop.
I have no doubt that they signed that, and I have no doubt that they violated it. My question is once it came to the attention of the drug court that they violated paragraph 13 or its successor, were they called in front of the drug court and explained to them that if they continued in the relationship, they'd be terminated, or did you just terminate?
On the day of the 20th of July, she decided to terminate.
And that's when it came to the attention of the court that they were involved in that.
Prior knowledge, we wouldn't for sure, but at that time, the judge, we had enough information at that time during the briefing and staffing. She felt like she had.
Was he present when that went on?
Yes, he was there on the 20th when drug court went on.
Did he make any acknowledgments, or was he given any opportunity to
He was
change?
very quiet when the judge gave out the sentence. Termination, yes.
You have anything else? Well, I just think I'm gonna take it under advisement. I'm gonna take it under advisement on the thing. Really, if you look at it, one of the reasons that I am given by the statute, and that's what I'm going to review, and one of the reasons I have to give, the findings I have to make of the statute, one of the findings is not to be supportive of what the drug court program is, or to make sure that it doesn't do damage to all the other people. You got all these people that you sit in drug court with, and you endanger what happens to them, whether the drug court is good or not when you done it, just because you couldn't discipline yourself long enough, to wait till it was over. Now your intimate friend is going to jail now. And I don't know whether you are or not, but you made a very bad choice here. Not that a lot of people have made bad choices. I'm not singling you out, make bad choices, but I'm in a kind of a difficult situation. I'll take it under advisement. I'll issue opinion on it. Okay.
Judge, he is also on a diversion. Do we want to set a review date?
I can't hear you.
He is also on a diversion. Do we want to set a review date for after your opinion for the next court date, depending on what your decision is?
Well, I'm going to enter an order, and in the order, if I revoke his pretrial diversion, then I'll order a pre-sentence investigation report. He would be sentenced on September the 21st.
Thank you, Your Honor.
Mr. Stockton, and I'll give both of y'all an opportunity to look at the grounds upon which a revocation can be made and what we should do based upon whether or not a violation of a policy of drug court where someone gets kicked out for a relationship is sufficient or not. To revoke a pretrial diversion. Those are two different issues, really. And in the past, it's always been clear that the people who violated some additional law or had dirty drug tests or that sort of thing. So I'll take a look at that.